The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, March 2nd, 2016 are currently trading with gold at $1,240 an ounce, silver $14.98 an ounce, Texas crude $34.40 a barrel, and Bitcoin is currently sitting at about 429 U.S. currency. Today in history, the year 1807, the U.S. Congress passes an act to prohibit the importation of slaves into any port or place within the jurisdiction of the United States. However, the widespread trade of slaves within the South was not prohibited since the children of slaves automatically became slaves themselves. The act prohibiting importation of slaves of 1807 went into effect January 1st, 1808. The beginning of U.S. abolition was today in history. In recent news, President Obama and First Lady Michelle Obama will both appear later this month at South by Southwest. The president is scheduled to take part in a discussion on March 11th with Evan Smith, editor of the Texas Tribune, on civic engagement and the role of innovative technology in increasing participation in politics and even solving major problems like climate change. On March 16th, the First Lady will be discussing her Let Girls Learn initiative, which aims to help an estimated 62 million girls around the world have access to basic higher education. This will make the Obamas the first president and First Lady to appear at South by Southwest in its 30-year history. Lawyer Jose Refugio Rodriguez said today that his client, drug lord Joaquin El Chapo Guzman, said he wants to be extradited as soon as possible to the United States because guards at the Mexican maximum security prison aren't letting him sleep. Mr. Rodriguez is wanting to negotiate with U.S. authorities for a lighter sentence and a stay at a medium security prison instead. Radio Formula reported El Chapo fears that his health will worsen because of the isolated conditions in the Mexican prison and the possibility that the lack of sleep could cause a heart attack or a stroke. The process of extradition may take up to a year. The world's biggest seller of corn and soybean seeds and the maker of Roundup weed killer, Monsanto Corporation, issued a profit warning today. They are forecasting a cut to the midpoint of its fiscal 2006 profit by at least 11%. This is after they announced laying off 3,600 employees, roughly 16% of its global workforce. Monsanto shares recently went down 7.5% and have shed a total of 29% during the past year. This is Rick Brody with your lowdown for March 2nd, 2016.
Okay, howdy. This is Randy Kelton, Rule of Law Radio on this Friday, the 4th day of March 2016. We have had a really nice winter this year. I hope we don't pay for it this summer, but now we're pushing towards spring. Everything's picking up. And even some of our court cases, we have been getting some pretty good cases in our, as far as the foreclosure area. We've been getting some really good rulings in our favor here recently. So it has the appearance of being a good start to this new year. We do have the phones open. We'll keep the phones open all night. And don't forget, we still have our fundraiser going. We had to put in an archive last night because Deborah had a gig she had to do so she can generate the funds to keep this thing going. So make sure you check out our sponsors, and if they got anything that you can use, make sure you patronize them if you can, because we get a percentage of whatever they sell, and that's the only way we profit from the advertising. And right now we need about all the help we can get. We still have a gun giveaway going on, so go to logosradionetwork.com and check that out. Help us keep this thing going. Okay, my goodness, we have a caller already, so I was going to go into this e-book that I've been working on, but since we've got a caller early on, I won't bore you guys with talking about artful vagueness. Artful vagueness is the next issue that I wanted to talk about. I personally find it very interesting. Maybe nobody else does, but I tend to get that a lot. If we run out of callers, then I will go back to that. I'll get pages up in my... Anyway, let's go. I'm waiting for the call screener to screen this call, so I don't want to get started into something. But artful vagueness. We spend a lot of time talking about things you should avoid when you're writing legal documents, and actually they go to any document. The section on being artfully vague, that's where you take all of those things that we warned you not to do, and you use those in order to affect people in a way that will cause them to become more engaged. I know that sounds a bit cryptic, but we will get to that next time. So right now we still don't have a caller up. Well, since we don't have a caller, I'm kind of stuck. I'll just go ahead with this. In previous show, we talked about things to avoid, like acronyms, pronouns, conjunction, mixing elements, emphasis, linguistic structures. The linguistic structures is where we go to the portion that applies to the concept we call artful vagueness. In order to be artfully vague, you only give the information that must be there and leave out the information that's superfluous. And when you do that, for instance, if you say you saw this person driving a 1964 Chevrolet, that's enough, unless the specifics of it are critical to the story. If the only thing that's important is a 64 Chevrolet, just say 64 Chevrolet. Don't say a green, rusty, beat-up old 64 Chevrolet. Because if you say you saw someone driving in a car, your reader's going to create in his mind a mental image of a car that most fits his personal preference. And then you say it was a green, beat-up car. Then he's going to have to take that car he had in his mind and turn it green and then turn it beat up somewhat. Each extra piece of information you give the person will cause them to take the image they've already created and readjust it to fit the details that you've given them. While that's important if the details that you're giving them matter, but if the details you're giving them doesn't matter, then what it does is makes your reader work harder to create in his mind an image that's in your mind. And if the image in your mind is not important, let them create anyone they want to. It'll be more, the narrative will be more compelling if you give them just enough information so they can create images in their mind. The images that contain the important details, but leave out the ones that are irrelevant. I read a book by Dean Koontz, and it was a mystery novel, and the hero was studying a cold case, and he tried to find the officer who had originally handled the case, but the officer retired and passed away. But since he was known to take a lot of cases home with him, the guy couldn't find the records he needed, he went to check with the guy's widow. And Koontz, the writer, described the place where this woman lived. It was a older, very well-kept trailer at the mobile home. He described the flower beds in front of it. He described the way the steps were designed going into it, the color of the door, the color of the paneling inside, the type of furniture they had. It just went on and on and on. If he would have simply said she lived in an aging, quaint, but well-kept mobile home, I would have created in my mind a quaint, aging, well-kept mobile home that was compelling to me. But instead, he kept forcing me to take my image and keep adjusting it and twisting it and add things and take things out, when in the end, none of those details were in the least bit important. It seemed as though he was just adding words to the narrative. I mentioned earlier on speaking to Lord of the Rings, where he described a character and spent 50-something pages giving this character's whole life history. And then he never showed up again in the whole trilogy. when I finished the third book and that elf never showed up again, I was furious. So when you're trying to be artfully vague, but when you're trying to engage your reader in the process, leave out the details that don't have to be there. We do that anyway. And one of the ways we do that is with deletions, distortions, and nominalizations. Nominalization, that's where you take a process and turn it into a noun. Angry, that's a nominalization. Angry is not a thing, or mad. That's not something that you get. That's not something that happens to you. It's a description of a set of behaviors. It's a way of acting. And we take a pattern of behavior and give it a name so that we can describe the whole pattern, or the nominalization. And nominalizations often create complex equivalence. Earlier we talked about avoiding complex equivalence. Well, when the equivalent is unimportant, when what you're speaking to is not critical to the fact structure, then you can use the term, his behavior made me furious. And the reader will create in his mind what for him represents this nominalization, furious. Now, what's furious for me may not be the same as what's furious for you. And if I describe my fury to you, you may not think that's very furious at all. You may not find it the least bit compelling. You may actually think it's somewhat wacko and extreme, or not compelling enough to actually be furious. You're only a little PO'd. But if you leave out the deep structure, leave out all of the defining details, your reader will put in details that are compelling to the reader. And in doing so, it engages the reader in the process. And nominalizations go along with deletions and distortions. These are when you're speaking of transformational grammar. These are primary structures. We speak 200 to 300 words a minute. And in speaking so quickly, in order to transfer meaning, we use terms that have deeper meaning than, say, the number one. The number one doesn't have much deep structure. It just is what it is. But frustration has all sorts of deep structure. We use terms that have subtle associated meaning that we don't supply. That way the reader, when he reads it, he'll have to supply that information. And distortions, I won't go too deep in distortions. I think we all understand what deletions and distortions are. But there's another way of using these I'll get into later. And if I'm a little sketchy in how I'm presenting this is something I've studied for a long time, but it's not something that I've ever tried to present to someone else. So I'm not as eloquent in presenting these ideas as I'd like to be. This is not the kind of thing you'll find in literature concerning how to write well. I have an extensive library on that subject, and none of this stuff's in there. And from my experience, this is the kind of thing that creates the most compelling prose, is paying attention to how the reader's mind moves with the narrative. Hang on, we'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio. And I went to this section because there were a couple of really interesting tools that I wanted to present, but I haven't structured this well enough, I guess, to be able to present it well. I did want to talk about conversational ellipsis and extended quotations, but I'll do that at another time. I'll study this out and build a better presentation for those. right now I have a caller, and if we run out of callers, I'll go to how the court works. That most of our listeners should find that a whole lot more interesting. And this is the kind of things they don't teach in school. This is how it actually works out here in the real world. Some of this we've developed. It looks like we have a caller that keeps dropping off. So, okay, I'm going to go to. Okay, my caller's back. It looks like we may have a little issue with our call board today. Okay, I'm going to go ahead and go to the caller. If we run out of callers, I'll go to how the courts actually work. Hello, Scott from Texas.
Hello, Randy. How are you? I'm doing good.
I'm doing good. What do you have for us today?
Well, today it was kind of a slow week because you were so hard to catch because you were so busy, but I finally got it straightened out about the 17.3, which people, if they're keeping up with this stuff, I narrowed the time frame way too small, and so I had to expand it out so I encompassed it to be 2 weeks before the date and 2 weeks after the date.
Okay, hold on. Let's back up and give some background here. He's talking about 17.30 Texas Code of Criminal Procedure, and it addresses what a magistrate is to do after the magistrate finishes an examining trial. He is to seal all documents had in the hearing. The voluntary statement of the accused, the complaint, and all other documents had in the hearing shall be sealed in an envelope, writing the name of the magistrate across the seal of the envelope. That is the only place you'll find that in anywhere in Texas law that I have ever seen. I've never seen anything ordered sealed anywhere else. And that's primarily because the magistrate is not the trial court judge. Well, the magistrate may wind up being the trial court judge, but not necessarily. When the magistrate acts in the magisterial capacity, he merely makes a determination of probable cause. And then under 16.17, he's to issue an order stating whether he found probable cause or released a person at his liberty, set him to bail, rendered him to the clerk of to the jail in the county. Whatever he did, he's to issue an order. And if there is no warrant, then he's to create a warrant. And now that may seem odd that the person is in front of the magistrate already, and the magistrate issues a warrant. It is the warrant and the order that when it is transferred to the clerk of the court of jurisdiction, that's what gives the court jurisdiction to hear the case. A magistrate has jurisdiction by virtue of the criminal accusation. Once the accusation is converted into a judicial determination of probable cause, that's forwarded to the clerk of the court that will have jurisdiction, and that moves jurisdiction from the magistrate to the court. 17.3 is the statute that directs the magistrate to take that action. And Scott requested that from, was this the municipality or the county court?
The county.
Okay, from the county court. So the request is, and I have it on jurisprudence.com, it says, you are hereby directed to provide by inspection and or copying all records collected, assembled, or maintained by the department that are specifically referenced by Article 17.30 Texas Code of Criminal Procedure. You may reduce the scope of this request by providing documents from this date to this date. And initially, Scott sent one that he was trying to home in on the time that he was arrested and charged. So he said, go ahead.
Actually, I put the time in when I was at court when she actually held the examining trial, because she said, I'm going to deny this motion for the cop or whatever, this criminal accusation, I'm going to deny that. And so I was rendering it during that time of that open court when she made that decision, which was my mistake because I didn't know it should have been a broader spectrum of time.
Yeah, and let me explain why. The reason we ask for a broader spectrum is nobody does this. Nobody in Texas follows this procedure, although it's very specific in the code. Nobody follows it, and so the courts just do what's convenient for them. And it's my position that our legislature did not write these codes capriciously. They had good cause for each of these codes. And our officials have just one by one made seemingly minor adjustments toward administrative convenience and adjudicative expediency till they reach the point that their practice doesn't even resemble the code. So we're asking them for something we're relatively certain they will not have. And we give them this wider scope so that it will establish that over a wide range of complaints, they don't do this at all. And not just that they didn't do it in my individual case. They don't ever do it because you can always expect a response saying, first thing that you get a response saying is, we don't understand what you're asking for. That's what I generally get. And I always tell them, well, if you don't understand what I'm asking for, ask the legislature. They wrote the code. I didn't. And then they never find that satisfying, but I don't care. And then they'll send me a response saying, we have no records responsive to your request. That's what you want. Now you can turn around and file criminal charges against the magistrate for failing to perform a duty he was required to perform. Is that how you got it, Scott?
Yeah, and this was the whole thing it's kind of leading up to because, okay, we put the criminal accusation in against the cop. Well, the judge denies it. Okay, fine. But the judge didn't seal the records up and do it according to the code 17.3. Fine. So now that has occurred, now I want to put a motion in to recuse the judge. Well, then that's not going to happen. We all know how that just gets wadded up and thrown away. But she has to have that hearing. Well, after that hearing, then I go back in, put in this criminal charge that I have against the judge in Addison, which I tried to get indicted. And now they already know that I've done this criminal charge against their own officer, and they didn't follow proper protocol. And she's already been recused from that, and she's still sitting on the bench. When I give her that criminal complaint and she sits there and has to stare at that thing, now she knows she's going to have to do the proper procedure on that. Sorry, I'm getting a phone call, but I'm not going to answer. But anyhow, so now she's going to be sitting there forced to touch this criminal complaint against the judge, and now she's going to be like, oh, man, I really hate that I have to do something with this, and then I'll have to go back in there and see her, and she'll have to tell me what she's going to do with that criminal complaint on the judge.
Yeah, and isn't this criminal complaint against the judge accusing the judge of failing to act on a criminal complaint?
Well, that would be later. See, I set her up with the cop, her own cop, because it's in Rockwall County, which is a different county. So now I try to get her recused. That don't happen. So now I've already got her on the hot seat for not filing paperwork correctly, and she has to file it on this judge.
Okay, hang on. We are about to go to break. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. This is a little bit longer break, so we have more time to go check out our sponsors and help support this network. We'll be right back.
Snacking can make you healthier, really. In fact, one tasty treat that's often considered a naughty indulgence should move right to the top of your list. I'm Dr. Catherine Albrecht, and I'll tell you what it is in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
It's time to go crazy for nuts. Forget about nuts being fattening. In moderation, they can actually help power up weight loss because they're packed with protein, nutrients, and fiber. A study by the International Journal of Obesity found that overweight adults who ate almonds as part of their diet plans lost more weight than those who ate more complex carbohydrates. And while you're losing weight, nuts can help prevent heart disease, cancer, and premature aging, especially walnuts. Researchers have crowned them the king of nuts because they contain nearly twice the health-enhancing antioxidants of other nuts. Plus, they're the richest in omega-3s. So go ahead. You can afford to go nuts for nuts. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, I got a warrant, and I'm going to serve them to the head government, them, prosecute them. Okay, What's that?
Okay, we are back. Randy Kelcom, Rule of Law Radio, and we're talking to Scott in Texas. Okay, Scott, so what is your plan moving forward here?
Well, now that the thing is, I'm kind of playing several steps ahead over in that court. So now I'm kind of backing up, and I want to fall back and regroup on a couple of other little cases that I got going. And I guess one of the questions I really have is, once I put in the request to get all the evidence of all the video and stuff, don't they have to give that to me, or can they deny me the video of the cops smashing my window stuff?
Technically, in Texas, although it's not in paramateria with Constitution, the courts have ruled that in a Class C misdemeanor, you don't have a right to discovery. However, since you don't have a right to discovery, then you can seek the records under the Open Records Act. Now, the code says that the Open Records Act is not intended to supplant discovery. So if you're in a trial, in any kind of a legal proceeding before a court, the statutes stipulate that you can't use the Open Records Act. So essentially, when you file suit or when you are sued, you lose your right to open records as it applies to the suit. And that's just because they want the judge to be able to control it for some reason, I don't know. But in a Class C misdemeanor, you don't have a right to discovery, so you should always be able to use the Open Records Act. And if the prosecutor claims that this is part of an ongoing investigation, then you request it under discovery. If they say you don't have a right to discovery and they won't respond to Open Records Act, now they've denied you in your right to a public court. And Open Records is great because a violation of that is a Class A misdemeanor in the state of Texas. In most states, the Open Records Act is not a civil statute. It's a criminal statute. In Texas, $10,000 fine, a year in jail. The legislature considered that a big deal. For the most part, these public officials don't, because if you try to prosecute one of them, all the other persons in the prosecutorial process try to shield them from prosecution. And that's what we're doing now is all about. Is we're taking the process of filing criminal complaints and working them over with it. Scott, here, you're going to file against this judge, and when the judge doesn't act on it, then you file on the judge. And they don't know what to do with that, because the problem is they immediately run up against the codes. And I've told more than one deputy or police officer or bailiff, man, don't get upset with me. I didn't write the code. I just read it. And here it's very clear what they're required to do. So kind of got off subject, but yeah, you put in the request. If they deny the request, then request it under the Open Records Act.
And then they'll deny that, and then you'll have to just file against the judge again, or file against the court, or would you file against the prosecutor? Or?
It makes a great question to ask.
Yeah.
If I can't have discovery and I can't get it under open records because it's part of an ongoing criminal case, then now I no longer have a public court. So now you guys, you cut out discovery in Class A misdemeanors because they're just about money anyway. You cut out discovery to make it easier and cheaper for you to prosecute. Now you run up against the Constitution. And the smaller courts, especially the smaller municipalities, they don't have the deep pockets that like Dallas or Fort Worth does. So when they start looking at you setting them up for a lawsuit, they're going to start getting real unhappy. And you wind up with more police officers pulling in behind you, following you for a little while, and then going somewhere else.
Well, speaking of that, as today, I was going to the gym this morning and had another nice officer get right up behind me, followed me for about a mile or so. He was real close at first, and then when I kept looking back, he kept getting further and further away till he just disappeared right out of my rearview mirror.
Yeah, once you've hammered them a time or two, they tend to not want anything to do with you. And in your case, since how many hits did you get on that video you posted at the cop breaking out your window?
Yeah, it's at 1.8 million right now. And
so,
a lot of LEO websites, too. They've been posting it around there. And, because a lot of them were trying to, bash and say, because they all label it as a sovereign movement, sovereign citizen and stuff. But, I never mentioned anything about it. And it's gotten a lot of traction and a lot of heads have turned on that thing, whether they like it or not, because I was never belligerent, never cussed, never said anything foul. And I just asked them if this was a custodial stop. Am I under arrest? Do you have a warrant for my arrest? And that was basically it. And, man, they have got a problem.
they're not going to want another 1.8 million hits on a video of one of their cops acting ignorant. So it doesn't take a 1.8 million hits on a YouTube video to get them not to want anything to do with you. And in this case, where they broke out his window, it's essentially committed assault against him. I suspect all the other officers have been warned, leave this guy alone because we don't want another incident like this. We don't want this guy suing us. Yeah, and I take it that's in the works.
Oh, well, yeah. In fact, I was wanting to, if there's no other callers right quick, I could read you the opening line that kind of went back because we got the criminal complaint against the cop. We tried to indict the judge for not letting me speak at a motions hearing with a Tarrant County grand jury. He got no bill. We knew that was coming. But now we're working on the criminal complaint against the cop to put this to a federal grand jury to indict the cop. And so if you want, I can kind of tell you that. And the main thing is when y'all are starting to start writing your papers is basically the lead in is why are you actually doing this? And what brought you here? Because you don't want to sound like you're crazy and you just fell off the turnip truck and you're the patriot sovereign movement king leader and you're going to set the record straight on how the Constitution was read in a court, because that don't happen these days. But when I was showing this to a lady manager, she was like, "Oh, well, everybody's going to think you're a patriot nut because nobody really understands what's going on." So the thing is, you want to try to make people understand what it is you're doing. And here is basically the opening after, I have reason to believe and do believe, blah, 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 blah. But this is what I was saying is the following is a complaint concerning certain practices and procedures in Texas. The complainant is concerned that these practices are not compliant with state law. This creates a serious conflict between an officer and the average person on the road. The problem is clear, yet the law is not. This ambiguity is a huge disservice to the cops and the people they are hired to protect. The complainant's goal is to resolve these differences so that law enforcement and we the people have a clear understanding of the law as written. And so I wanted the people to understand that I'm wanting to educate the reader of what these problems are and how we address them.
Okay, hang on. This is... am I looking at... Oh, there's my clock. I lost my clock for a second. Randy Kelton, Louisville Radio. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Louisville Radio, and we're talking to Scott in Texas. Okay, Scott, go ahead.
Okay, that was basically the lead-in sentence, and now this is the part that Randy helped me out. He worked in, and this was pretty much a lead-in. I just kind of tweaked it just a little bit just to see maybe, but let me just read it for you real quick. It's real short, so it's not going to take a lot of time. But after it says, I've been stopped by officer, blah, 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 for speeding. Okay, complainant has been studying the traffic codes and found that it is clear that the state may only license commercial professionals like lawyers, doctors, plumbers, electricians, and so forth. Complainant had a regular state-issued license considered by the state as a commercial chauffeur's license, which is a dual license. This license grants the authority to transport up to 8 people for compensation or hire. At the time, complainant was not using his commercial license, but rather was traveling. Therefore, complainant calmly and politely asked questions to the officer to determine whether or not he had reason to believe complainant was acting in commerce and violating state law. And then the rest is just the complaint. But the whole thing with that, the first couple of sentences was to lead the reader into understanding what the problem is, how the problem is unclear, why the actual person, me, had questioned the officer, because I had reason to believe after studying the code that there was a discrepancy, and I wanted to address this discrepancy in a calm, polite manner, so you didn't look like you're sitting there cussing. You don't have the right to pull me. You're not doing that. You're actually trying to present a case in a calm, presented manner. And so, what do you think?
Well, the 1.8 million hits on the YouTube video probably kind of speaks for itself. And it has been my experience that policemen are trained to take absolute, total control of a situation. They're trained to believe that if they don't secure absolute, unquestioning obedience to every order barked at a person, then they're to fear for their lives. And that seems to be exactly what they do. If you don't do exactly what you're told, the instant you're told, the first reaction the policeman has is he moves his hand toward his pistol. I had a friend who retired from a local police department, and he said in 20 years as a police officer, he never once had to pull his weapon. He said there were plenty of opportunities where he could have, but he always found other ways of handling situations rather than using his pistol. Policemen in the last 20 years or so had been trained to go to the pistol as a first resort instead of the last resort, and we need to get that fixed. And we're working on it. Scott is going to file against the officer first-degree felony aggravated assault. And the reason he can do that, and actually I just filed with the Texas Ranger first-degree felony aggravated assault against my local district judge. Because while trying to exercise a statutory right, I was threatened with arrest by the judge, and he sent a bailiff to carry out the arrest, and the bailiff actually put his hand on my arm while the bailiff was prominently displaying a deadly weapon. It is my allegation that the judge threatened me with arrest by this armed bailiff for the purpose of preventing me from exercising a constitutional right. Now, our legislature considered that pistol that police officer was so prominently displaying as very serious business. And they made it clear that when that officer straps that pistol on, he straps on a considerable responsibility. And here's how they made it clear. 2202 B2A Texas Penal Code. If a person commits simple assault under 2201 Texas Penal Code, which is a Class C misdemeanor, and they are prominently displaying a deadly weapon. Now, simple assault is offensive language or offensive touching. Does not require injury. If they commit simple assault while prominently displaying a deadly weapon, that's a felony of the second degree. Unless they are a public servant acting under the color, meaning pretense, of an official capacity, in which case it is a felony of the first degree. Our legislators considered the use of that weapon by a public official to be very serious business. Now, Judge Fostel, district judge of the 271st District, Wise County, Texas, threatened to have me arrested by a bailiff who was prominently displaying a deadly weapon. So, since the bailiff was acting at the behest of the judge is responding ad superior. He was acting in concert and collusion. So I filed the complaint with my local Texas Ranger. And Scott, I'm glad you gave me a lead into this because it was something I have been wanting to address. the Texas Rangers historically have been forbidden to investigate a public official without the express written permission of the director of the Department of Public Safety himself. Well, last September, Texas Government Code 411 went into, was passed into law that became effective in September. And the legislature, what that one did was took away the ability of the prosecutor, attorneys, public integrity unit to investigate public officials and gave that authority to the Texas Rangers. And the Texas Rangers set up a set of protocols they were required to by statute. And I questioned our local ranger about these protocols. And he said their protocol is that they only investigate something if they're requested to by the district attorney. And I questioned that because I read the statute, and the statute didn't say that. Well, that's our protocol. And I assured him that I wanted our Texas Rangers to be more independent. And it appeared the legislature wanted our Rangers to be more independent. But the politicians in office helped craft these protocols to circumvent the statutes. So I'm going to bring you a verified criminal affidavit accusing a public official of a crime. He said, well, I won't accept it. I said, I don't care what you do. What I'm going to do is invoke your duty. And then I questioned him because the Texas Administrative Code that creates the Department of Public Safety designates the Department of Public Safety personnel as police officers as opposed to peace officers. And as a police officer, the Department of Public Safety personnel can enforce the traffic code. As a peace officer can enforce the criminal laws, not a DPS officer. The code specifically stipulates the Department of Public Safety shall not enforce the criminal laws except at the request of and under the direction of local law enforcement. And that's because these guys were police officers, not peace officers. Now, they may have a peace officer certification, but they were not employed as peace officers. You know, there are security guards who are also policemen. But when they're a security guard, they're not a policeman. Yeah, they're a certified peace officer, but they're not at that time employed in that capacity. DPS officers are not employed in the capacity of police officers. I'm sorry, of peace officers. They're employed as police officers, traffic cops.
Right.
Texas Rangers are a part of the Department of Public Safety. So I asked the ranger, are you a certified peace officer in the state of Texas? He said, yes, I am. I said, are you employed in the capacity of a peace officer or in the capacity of a police officer? He said, a peace officer. Okay, I'm not sure if he's right about that, but I'll accept that. So as a peace officer under 2.13 Texas Code of Criminal Procedure, he has a duty to enforce law. And when I make it known to him by a verified criminal affidavit that a crime has been committed, that invokes his duty to enforce law. So he's going to refuse to perform that duty. That works for me, Bubba. Then I go back and I file against him for shielding from prosecution, violation of 3805 Penal Code. That's a felony in the state of Texas. So, you don't want to do your job? Well, that's our protocol. I don't care about your protocol. You got your protocol. I got my Constitution. I got my statutes. And I got my authority to ensure you abide by my statutes. So I'm going to go after the ranger and then let the ranger make the argument that he is acting in good faith reliance on competent authority, and let's see how far that gets it. Hang on, Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. Give us a call. I think we're going to the top of the hour break. This is our 3-minute break, so it's a real good time to go see our sponsors and help support this radio station, and especially donate to Randy's Beer Fund. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term Riley.
Okay, we are back. Randy Kelton, Rule of Law Radio. And when we went out, we were talking about how to get the Texas Rangers in a position to where they're not under the thumb of prosecuting attorneys. And while this Texas Ranger may not like the process, this is the most effective way I can see to demonstrate the problem with the issue. I live in Wise County, Texas, and I'm pretty well known around the courthouse, especially the district attorney. He knows me real well. And I've already warned him that this is coming. So he will immediately recuse himself. And then they'll have to appoint a prosecutor pro tem. And when the prosecutor pro tem tells the ranger not to pursue and not to investigate or file the criminal complaint, then I get to file against the prosecutor pro tem. I'll eventually wind up bringing this complaint to the grand jury myself. And this is a great complaint to bring because I was trying to challenge the grand jury pool. Now, that's in the code, but I've never heard of anybody doing it. And when I went down to challenge the grand jury pool, the judge just impaneled the grand jury without giving me opportunity. That's what precipitated all this. Seems like a minor little thing, just a minor technical little issue. Well, I want to demonstrate to him how deep it gets when you start messing with one of the masters of the servants. He's the servant, I'm the master. And he wants to play fast and loose with his authority. We'll see how that works out for him. I once before I filed making a terroristic threat against him. And he kind of hates me for that. Or he's going to hate me even worse when we get done with this one. Because once I work this through the system, this is all about testing law. If we can get this to work out right, if I can get this ranger to scream bloody murder when I come after him criminally and come after him for following policy, he is not going to be a happy camper. We may well encourage the Department of Public Safety to reset their protocols so that they don't go to the prosecuting attorney and get his permission to investigate a public official. If we can get that done, we change everything. Does that make sense, Scott?
Oh, I'm wholeheartedly agreeing. I was just, I'd heard one time, correct me if I'm wrong, that what if like 24 people came into a courtroom? Isn't there a way that they can convene their own grand jury?
I've heard that, but I've never found any credible substance to it.
I haven't either, but I've heard it.
Yeah, well, you hear a lot of stuff out there. And when you try to convene a grand jury,
But the judge has the authority to set a grand jury, because I was reading up on grand juries and stuff. I mean, he has the authority to set a grand jury, but I don't know. There's not enough.
Okay, a district judge consecrates the grand jury. That's what Scalia called it. It's a district judge will impanel the grand jury.
Right.
But once that grand jury is impaneled, then the judge has nothing to do with it. They're a separate entity. Scalia called it the fourth branch of government, because they are independent of the district court. They're an entity in and of themselves. Well, prosecutors really don't like that. They would rather make the determination of whether to pursue prosecution or not. They don't like having to take this to a grand jury because they're the ones that have to prosecute. And they feel like they're the ones that should make the decision as to whether or not there's sufficient evidence to warrant a prosecution. But our legislators knew better than that. They knew that that was not the criteria that would be most important to the prosecuting attorney. They put statutory requirements in there to ensure that justice was his purpose. 2.01 Texas Code of Criminal Procedure says it shall be the duty of the prosecuting attorney not to secure conviction, but to ensure that justice is served. He shall not seek witness or evidence, nor show the innocence of the accused to mitigate the guilt of the accused. Now that's paraphrasing somewhat because it's a little more long and convoluted than that. But that's just what it requires. Well,
Right.
however honest and conscientious the prosecutor may be, at the end of the day, he has a caseload that he has to clear. While he may want everything to be just and correct and exactly the way the law requires, he's still got this caseload that he's got to clear. So at the end of the day, what he's interested in is making a deal. So when he evaluates a case, he doesn't evaluate it based on sufficient probable cause. He evaluates it based on how difficult it's going to be for him to prosecute and how likely is it for him to be able to create a deal out of this. Do you know what the average conviction rate in the state of Texas for all crimes across the board?
The average conviction rate is probably like 95%.
99.6.
That's even scarier.
It rounds up to 100. Worst police state the world has ever seen, and nobody even knows. The reason it's 99.6 is because everybody takes a deal. And the reason everybody takes a deal is every step from arrest to trial, as presently practiced in Texas, is not only wrong, it is very specifically against particular law. And if you look on jurisimprudence.com, there is a writ of habeas corpus I prepared for a kid in Conroe several years ago. And that walks through the code and demonstrates the difference between the code and the practice. And it shows how every step is not just against law. It's against law for a very specific reason. The practices and procedures that they used are structured the way they are to place any person accused of a crime in a position such that he has no reasonable option other than to take a deal. So the prosecutor wants to make a deal, and that's why grand jury is in place. Grand jury don't care if it makes a deal or not. They care about whether or not there's sufficient probable cause. And we need to get back to the grand juries, especially with public officials. Yeah. These officials have went to great trouble to shield themselves from it, and we want to break that down.
That's the whole key right there. All right. Well, you got any more callers? Or you need to...
Yeah, got a full board. I was just going to dump you like a hot rock.
All right. Tear them up. Y'all have fun now. Good night.
Okay. Thank you, Scott. Okay. Now we're going to go to Rob in New Mexico. Hello, Rob. What are you up to these days?
Huffing diesel fumes.
Wait, say that again. Missed that.
I said huffing diesel fumes.
Oh, okay. So how is your... Oh, finally got that. Diesel fumes.
That's your joke, Randy.
You see, Rob is a truck driver, so if he sounds kind of strange sometimes, that's because diesel fumes cause deadheading.
Mm-hmm.
That's one of my funny truck driver jokes, in case nobody got it. Oh, well. Okay. How is your foreclosure issue going and your suit against the lender?
Well, okay. Just to clarify, it's not a foreclosure or a lender. It's a two-party seller finance contract, real estate contract. So there's no loan. There's no actual foreclosure. All they have to do is file the special warranty deed and a notice of default, which they have done. But they did it after I filed a notice of seller's default, and they did it after I sued the second servicer under the Unfair Practices Act. So where we're at right now is I have a motion hearing coming up next Monday, the 14th, for a motion to dismiss from the original escrow servicer and a motion to dismiss.
Wait a minute. Whose motion?
The original escrow servicer filed a motion to dismiss because I sued them. I sued the original servicer, the lenders, or I'm sorry, not the lenders because they're not lenders, but the sellers. I sued the seller's real estate company, and I sued the seller's son, who is the broker.
Okay. The motion to dismiss, that's only with the one party, or is it all parties?
There is the escrow servicer and its owner, who I sued personally. His name is Rick Tom. So there's Security Escrow and Rick Tom, the owner of Security Escrow. I sued them. They filed a motion to dismiss. I sued their attorney, Peter E. Springer, and his fake company, Real Estate Law Associates, and they filed a motion to dismiss. Now, this attorney works out of the escrow company's offices. His web search for him on the internet comes up with the escrow company as a result. That's the only result you get when you search for him online. That automatically redirects to the escrow company. So I'm claiming that he is a part of the escrow company doing escrow business. He's claiming that he's not doing escrow business, that he's an attorney. Now, my question on this part is that the escrow company, through their attorney, completely misrepresented the facts of my complaint. So I filed a motion for sanctions against them and their attorney. I'm wondering, should I file a criminal complaint against him for perjury?
Wait a minute. Were you asking, should you or are you going to? But hang on, let's pick this part back up when we get back on the other side. This is Randy Kelton, Groove Law Radio. Our call-in number, 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pockets, took the money from my hand. Ain't gonna fool me with that same old trick again. Ain't gonna fool me. Ain't gonna drop me with that same old sucker punch. I get it now, but then I must have been out too much. Back then you had room to move, but now you're feeling the crunch. Ain't gonna get me with that same old sucker.
Okay, we are back. Randy Kelton, Groove Law Radio, and we're talking to Rob in New Mexico. Okay, Rob, I missed that last part. Were you asking, should you file criminal charges against the lawyer for perjury, or did you say you, or are you saying you did file criminal charges?
I'm asking if I should.
Absolutely.
Okay.
I'm about to do that to a lawyer here, where I filed a quiet title action, and 4 months later, he filed a removal claiming that he wasn't served. But I've got emails showing that he was served. A week after I filed the suit, he called me. So even if he claims that he wasn't properly served, he had notice anyway. So, and he made a lot of statements that were just absolutely untrue. So I'm going to sting him good.
Okay, good. I'll do that. Now, my next question is, they're whining that I called what they say is conversion, that I called it theft, and they're claiming that it should be, that the theft claim should be dismissed for that. That's not a valid reason, right? I mean, if the facts are there, it doesn't matter what I called it.
Right. It is what it is. And the words you used doesn't make a difference. Did you claim theft as a, wait a minute, hold on. Conversion. You referenced the term conversion. In Texas. Okay, go ahead.
Okay, in New Mexico, apparently conversion is the civil version of stealing somebody's stuff.
That's exactly where I was going to go, because the law used to be that stealing someone's property was conversion, the real property. But if they changed it, so now stealing somebody's real property is theft, and the civil version is conversion. So you claimed conversion and theft, or just conversion?
I claimed they stole my stuff, and I called it theft. They complained in their motion to dismiss that I misnamed it and that I should have called it conversion, and that, you know, that's one of their reasons for why my complaint should be dismissed, because I didn't call it conversion, I called it theft.
Well, the courts, I'm sure New Mexico is the same, are required to consider a motion or pleading for what it is, not what it's called. Yeah. So that's not likely to go anywhere. But at worst, they'll ask you to amend the pleading and change the term theft to conversion.
Mm-hmm. Okay.
And when they do that, then you take the theft complaint straight to the DA.
That's what I was thinking.
Yeah, we can handle this, Bubba. And never mention theft again, and only conversion. Right. And if they mention the fact that you file criminal charges against them, you object and ask for sanctions, that they are not allowed to use criminal to gain leverage in a civil action.
Okay.
Even if it's criminal charges against them. But unlikely they'll bring it up. But that's certainly what I'd like to do, because I'd like to keep raising the stakes. This lawyer I'm about to sting, I told him that we filed suit against him, but just the only reason we filed suit is so we'd find out who to talk to. That we really wanted to just work out a deal we could both live with. And if he'd agree to mediate or to negotiate in good faith, then don't even bother answering it. Well, he didn't answer. And then they didn't negotiate in good faith. And then 4 months later, he removed it and filed this absolute boilerplate denial. And what I had filed was a quiet title action claiming rescission. And he included the rescission document that we had sent him, the notice of rescission. And in his answer, he never once addressed rescission. So I'm going to claim that his answer is 3 months late. And then even if it weren't 3 months late, it's insufficient as it fails to specifically deny the specific allegation. So I'm going to ask for default judgment. And then I'm going to bar grieve him and ask for sanctions against him for failure to speak with candor to the court. Say, you want to play hardball? We'll introduce you to the deep end of the pool.
Well, that goes to not my next question. This one was further down my list, but you just opened the door to it. The fake escrow servicer that I sued under the Unfair Practices Act, separately from everybody else, because I have no evidence that they're involved other than their claim. One of the things I cited was that they were required under the Uniform Commercial Code to act in good faith, which in New Mexico is Statute 55-1-304. They came back among other claims stating that the Uniform Commercial Code does not apply to real property transactions, that it only applies to movable goods and services. And in that claim, they said that because it doesn't apply, that the requirement to act under good faith is inapplicable.
So they're not saying they didn't act in bad faith. They're just saying you can't claim they acted in bad faith.
So we can take that as an admission of acting in bad faith, can't we?
I would think so. And it's going to be in the canons of, in the bar standards, that they have a duty to act in good faith.
Well, and Rule 11 requires that filings be made in good faith, right?
Filing fees made in good faith?
That filings be made in good faith, that they not be done for any improper purpose?
Yes. So I don't think they're going to get around the good faith issue that way.
Yeah.
Because there's more things that require that they act in good faith than just the Uniform Commercial Code. The Uniform Commercial Code, as far as I know, does apply. Do you have the Uniform Commercial Code enacted into New Mexico law?
Yeah, it does. And 55-2, which is Article 2 of the UCC, specifically says that it only deals with sale of movable goods. So it does not, in New Mexico, it does not apply to the sale of real estate.
Oh, okay. Because normally there are sections in there that do specifically address real property.
Right.
So you may not have that may be adjusted out in New Mexico.
So
they're saying that since the Uniform Commercial Code doesn't require them to act in good faith, that's a great. I would love to get an argument like that, because I would state that their arguments are well taken and move the court for a leave to amend to claim a lack of good faith under bar standards or something under their professional conduct code. Hang on, about to go to break. Randy Kelton, Real Law Radio. Our call-in number 512-646-1984. Give us a call. We'll keep the phone lines open all night. We'll be right back.
Could your pharmacy release your prescription information to marketers? Believe it or not, it's not only possible, it's probably been done. I'm Dr. Catherine Albrecht, and I'll be back with loopholes that make it legal for companies like CVS to share your personal health information.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Your pharmacy may be sharing your medical information without your knowledge or consent. For example, CVS pharmacies are likely to disclose your personal health information to business associates. A loophole in the law allows it if parties agree to execute a contract to, quote, safeguard the data. Business associates could range from marketers to insurance companies. And while they might keep information locked up, there's no telling how it might come back to bite you. Ask your pharmacy to disclose how it shared your previous data and request in writing that it not be sold, rented, or shared. And most importantly, take your future prescriptions to establishments that guarantee real privacy. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Trails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Real Law Radio. We're talking to Robin in Mexico. So, you filed criminal charges against him for perjury, and he doesn't feel like he has a duty to good faith. That should be wonderful. Have you looked at the New Mexico Bar Association standards?
Oh, yeah. I've filed over 10 bar grievances so far in this case. So I'm working on some more out.
Only 10? Did you run out of ink?
Well, I've only got 4 attorneys. There's 16 defendants in 3 different cases, and there's only 4 attorneys. So,
well, we had Eddie Craig when we first talked to Eddie Craig. He was living in Nacogdoches, and he would call into the show having a problem with sales tax, and he wanted to know how to take action, and we went through filing criminal complaints. And then a couple of weeks later, he called back and said he filed some criminal complaints. I said, well, how many filed? It's 400 and something. I said, only 400? What's the problem? I ran out of ink. So,
well, that's pretty much my problem is I did run out of paper and ink. I've got that rectified now. I got a new printer, and hopefully it's going to work.
If we're going to take back the system, this is the way we do it, because criminal, it introduces a whole different paradigm. Everything changes when you start filing criminal against them. Now they're going to have a whole different set of issues to deal with. And this is, Mary Krennick, I was kind of hoping she would call in tonight. We had a discussion up here. She came up here to Dallas. She's from Austin. And we were talking about filing criminal charges. Generally, if an ordinary individual files criminal charges, especially against a public official, the other public officials are going to do everything they can to shield that public official from prosecution. The problem is, it's not so much that they're afraid of you. What they're afraid of is you are bringing to the table cannon fodder that one of their political enemies can use against them. That's what they're afraid of. That's why it's important that we do this. Because when they run for office the next time they got to consider that their opponent will drag these criminal complaints out and shake them in front of everybody. And whoever it is going, or they're going to say, oh, well, these complaints, they were all frivolous. But they know that the public will look at that and say, if this guy acted bad enough that somebody had to file criminal charges against him, that's a big deal. Where there's smoke, there's fire. Whether there really is fire or not, it goes to Ken's 4 rules. And the first rule is perception is everything. So we start filing these, and here you're filing against a lawyer. Well, the lawyer knows the judges and the clerks and most all the people in the courthouse. He don't feel like they will hammer him, but he also knows there's nothing to keep him from it. And if this scoundrel truck driver winds up getting these complaints in front of a grand jury, these guys could end my career. They could cost me my bar card, maybe even put me in jail. So, in the end, this is a big deal. We need to do more of it. Not to get someone indicted, but to give them a reason not to do anything that could get them indicted. So, when you file these criminal charges, Rob, you have to exercise self-discipline.
Mm-hmm.
You cannot allow yourself to enjoy it too much. It's just wrong. You have to feel bad and morose because you're forced to file these criminal charges.
Well, honestly,
my father used to say, oh boy, this is hurting me more than it is you. And I'm thinking, no, it's not. Anyway, okay. So what's your situation now? What are you looking at in the near future?
Now, while we're on this, I have a federal case under FDCPA against an attorney, Timothy D. Steiter, and his law firm, Steiter and Associates, for failing to validate a debt and continuing collection and all that stuff. In exercising due diligence and doing my research, I found out that the fake escrow servicer operates out of the same office as this attorney and his law firm. And when the fake escrow servicer filed their motion for summary judgment, they included with it an affidavit from their CEO admitting that they obtained the account when it was in default. So I had to amend my FDCPA complaint and add the fake escrow servicer and the CEO and its officers. Turns out one of the officers of the fake escrow servicer is a fellow named Tim Steiter. Now, I don't know for a fact that Tim Steiter is Timothy D. Steiter of Steiter and Associates, who I already sued, but I'm guessing that since they operate out of the same office, there's probably a pretty good chance it's the same guy.
Oh, my goodness. If he is an officer in the company, he can't represent the company.
Oh, he's not representing them in court. He was just acting as a debt collector after I sent them a validation letter. I sent the fake escrow servicer a validation letter and asked them to produce a full accounting and the original documents. They ignored it, and I started getting letters from this debt collector attorney. So I sued him, and I sued them separately under the Unfair Practices Act, not realizing that he was part of the same company.
So you will amend to name him in the Unfair Practices Act action?
Well, yeah, I haven't done that yet, but I did amend the FDCPA complaint to name the escrow servicer that admitted obtaining the account when it was in default.
Okay, be very careful. You can get the whole thing tossed for failure to name an interested party. I'm not sure. Naming the interested party as a plaintiff, Leslie in Pennsylvania took on a foreclosure issue, and the mortgage was in her and her husband's name. She fought this for 4 or 5 years, and the judge threw it out for failure to name a necessary party, which was her husband, who was on the deed of trust. So, depending on what relationship this guy has, he may or may not be a necessary party. It's sure worth refiling to name him. Have you done any discovery to determine his relationship?
I just sent it off. The federal case I have not done any discovery yet. Everybody in my state cases has been hit with discovery now. Clock's counting on that. Their deadline's not up yet, but the deadline, the folks moving to dismiss in my state case, their deadline for discovery comes before the motion hearing. So we'll see what they show up with.
Oh, wonderful. So if they don't bring the discovery before the hearing, then you move for an abatement.
Yeah.
To abate the hearing until they come up with a discovery. Good.
Yeah. Now, going on with my FDCPA case, the deadline for the original defendants to respond was February 19th. And I hear the music. Don't fall off the edge. Randy?
Oh, somebody muted my mic again. Okay. Hang on. We'll be right back. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Well, you know, karma is lurking around the corner. You better watch every step you take. And good will follow you. Yeah, brother Jerry, sing reality.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Rob in New Mexico. Okay, Rob, so what else you have for us?
Next question. The federal case, the FDCPA, first party, the debt collector attorney and his law firm, they have not answered. Their time to answer was the 19th. Does filing the amended complaint adding defendants affect that time to answer?
Yes.
Or is it just default?
Yeah, don't do anything. If you don't have an answer, don't do anything. You have proof of service.
Yes, I do.
Perfect. Then file a motion for default judgment. No answer default.
Okay, so that amended complaint doesn't affect the original service of the original defendant.
Wait a minute. Did you? Yes. Did you file an amended complaint?
I had to. My time to amend without leave was 20 days after service. So,
wait a minute.
Otherwise, I would have had to get leave from the defendants.
Okay, so you filed an amended complaint within the 20-day time period.
Yeah, they got it on the last day.
So has there been 20 days after they received the amended?
No, not yet. In fact, the parties have not been yet. I just got the service back from the court a couple of days ago, so I need to get them served on Monday.
If you haven't served them yet, you might want to that's really mucked up the works. If they hadn't filed, you should have filed a motion for default judgment with no answer default. You might have screwed that up. So
I might have. I probably should have sued the other guys separately.
Yeah. So you might want to wait and see if they get them served and then give them the time and see if they respond to this one.
Okay.
Because it might have just fell through the cracks and your amended complaint might have bailed them out.
Yeah. Well, I'm thinking he probably looked at it and it was, very small FDCPA complaint. And he's like, this isn't worth fighting. Not realizing the actual damages part, because this is the same guy that filed the notice of default and the special warranty deed into the county records. So he is directly responsible for any damages I suffer.
Okay, well maybe he won't answer the amended either.
Yeah.
Okay, so just
now
don't make a peep. Be real quiet. Maybe this one will fall through the cracks.
Okay. Well, and then I got a call from an attorney on the 24th, claiming that he's the attorney representing this guy. He left a voicemail. I didn't get a chance to answer the call. I haven't called him back yet, and I frequently don't get calls because my service drops out.
Okay, it's suggestion. If you talk to him on the phone, give him your email address and nothing else.
Mm-hmm. Well, I haven't talked to him yet. He hasn't filed an answer and hasn't filed a notice of appearance.
Yeah. Okay. So if you talk to a lawyer, make sure the only thing you talk to him about is your email address, because they will absolutely lie about what's said on the phone.
Yeah.
Okay. Do you have anything else for us?
One more. I have a motion for judgment on the pleadings from the real estate broker and the real estate agency, the realty company that I sued. Now, company is co-owned by the seller with her son. Her son is the broker. They have separate attorneys. The two sellers, the husband and wife, have an attorney, and then the broker and real estate company have a different attorney. So the real estate broker and the real estate company filed a motion for judgment on the pleadings. Now, would the broker and the company be in any way liable for the breach of contract of the seller?
Wait, hold on. Motion on the file for judgment on the pleadings. Have you been through discovery yet?
No.
Then you should object to the motion because until discovery's been completed.
Okay. Good deal. All right. Well, I guess they're
trying to short circuit the system.
Okay. That solves my other questions then, because the other ones had to do with the judgment on the pleadings, and if that's the case, then I don't need to ask those yet. I'm done.
Okay. Thank you.
One more.
Go snort some diesel. Okay. Thank you, Rob. Now we're going to go to Mark in Texas. Hello, Mark.
Hi, Randy. Good evening. I've got something kind of relevant there. I wanted to ask you first, relative to FDCPA issues, is it possible that there might actually be pre-litigation discovery that's done and you can use the federal court to compel that discovery?
Yes, but the federal court, for the most part, it only allows depositions. Unlike Texas is different in every other state. It allows all kinds of pre-litigation discovery, but in the federal court, I think it's Rule 72. I'm not sure, but it only allows to take depositions. But depositions are a great way to intimidate the other side. So yes, you can get pre-litigation discovery.
Yeah, well, I would love to be able to do that. I have an FDCPA suit. I've been looking like mad trying to find an attorney who could help me file that. I found one guy that I love, but it turns out he actually works for the banksters in another state, and he told me he didn't think that he would be able to do that. But he was very, very straight shooter. Anyway, kind of an irony. But with respect to this is very interesting in that I've spoken to maybe 5 to 10 people, and they seem to have this issue with the idea that I want to file an FDCPA suit against a servicer that filed essentially a fraudulent transfer that seemed to give the plaintiff in a case that came about standing to bring that suit. I mean, it doesn't seem to give them that, but I think that's why they filed that assignment when they don't otherwise have to do it at all. And I'm just very curious to get your thoughts on this idea. There's a servicer that filed this fraudulent transfer in 2013. This servicer, basically a week later, I end up getting sued for foreclosure, and that lasts for a couple of years. During this time, this servicer sent me letters. They would regularly send me letters. As I understand it, with respect to FDCPA, there's case law which suggests that if it's a time-barred debt, they're supposed to at least notify you of that. They're definitely not supposed to threaten to sue you over a time-barred debt because they can't do that.
That comes under 15 U.S. Code 1692E, I believe.
That's part of the FDCPA 10 pages of information, right? Or 10 pages of the Fair Debt Collection Practices Act, right?
Yes, under 1692E, they're forbidden to threaten to take an action they do not intend to take or don't have the authority to take.
Yeah. Now, I want to ask you about this and just get your take. The servicer is not the party that brought the lawsuit, and but yet they're talking about it. And in the subsequent letters, I have something which says, in the same letter, I have something which says it's in litigation. And then in this letter, the way they would do this, because they, of course, want people to be aware and be responsible, there's something in the letter that says, as of X date, your loan is now something like 3,600 days past due. Altogether, if you add it up, it ends up coming to somewhere in the realm of about 7 years. and it literally shows, it literally, damns them with respect to the idea that this is something which was filed past the statute of limitations. So it's an interesting matter. I think we could definitely say that these letters, which are within the statute of limitations, reveal that this lawsuit shouldn't have been filed based on that. And these letters also reveal that they have taken an action which they didn't have capacity to take, based on this clear-cut 5-year statute of limitations. And that's a little bit false and misleading. And anyway, but where I was going with it is I wanted to ask you, is there a situation here where, let's say, the servicer is A, the plaintiff in the case is B. Plaintiff in the case B files the suit. I question the assignment in my original response.
Wait a minute. Plaintiff is B. How did plaintiff establish standing?
Well, it's an interesting question. And
who is plaintiff? Who is plaintiff relative to the mortgage contract? So, okay, we're about to go to the top of the hour break. This is Randy Kelton, Real Law Radio. I call it number 512-646-1984. We have a full call board, and things tend to pick up toward the end of the show. So if you try to call in and you can't get through, it's because our board will only hold 4 calls at a time. We've got those 4 calls. As soon as someone drops off, if you want to call in, then call in then and we'll get on board. Okay, this is Randy Kelton, Real Law Radio. Call-in number is 512-646-1984. We'll be right back.